Well, imagine you're a small business owner who's been robbed 4 times. You've lost thousands of dollars. You think it might be one of your employees who's robbing you blind. So you decide you're going to stake out your own business with a shotgun by your side for your own protection, hoping to catch the thief in the act. Not really something I would do, but hey, it's a free country. Well, your worst fears are realized when you catch a senior employee going for robbery number 5, a guy you trusted and gave a break to. You order him to freeze, but he takes off. You shoot up in the air 2 times. Then you fire twice more at the getaway car. You pump that gun and you shoot at the tires 2 times. They pick up the bad guy, but then they come back and they arrest you. That is exactly what happened to one Boston businessman who's now facing gun charges for trying to protect himself and his business. Even worse, prosecutors say they may force to drop the case against the thief. This isn't disregard for the Second Amendment. This is an insult to plain common sense. Michael Bergeron, he is the attorney for David Kress, the man who was trying to defend himself against another robbery. Michael, like I said in the monologue here, I wouldn't have done this. Why did he? Why did he not, get a video camera and call 911?
Well, frankly, he was frustrated at the events over the past 6 months. He does have a lawful license to carry his firearm, and he did report the first 2 incidents in October of 07 and February of 08, after which no suspect had been found. He was acting on his own suspicions and that he would be able to at least confront the intruder that night.
Okay. You can have a concealed weapons permit, and God bless you for carrying a gun, and you have a right to defend yourself and your property. He never fired at this robber, who turned out to be somebody he gave a break to, right?
That's correct. He never fired at him. There were 2 warning shots fired to the side after they were out the exterior door of the building. And then as the car, which was about 3 feet from him, as the car was leaving with his property in the back, he fired at the 2 front tires before the car exited. He didn't pursue the car or shoot at the car or Mr. O'Connor after that.
Okay, and then when the cops came, they actually told him, good job.
That's correct. That's accurate. They're actually thanking him. The local police officers were actually thanking him at the scene that night. And David was not arrested that night. It wasn't until the next morning where information was being presented to him that the police chief was thinking about taking charges out against David.
Okay, and what are the charges and how long could he serve?
There's 2 charges. There's assault with dangerous weapon, which carries up to 5 years in state prison. It's considered a felony here in Massachusetts. And then the second charge is discharge of a firearm within 500 feet of a dwelling. That carries up to 90 days in the House of Correction and a $100 fine. The assault with a dangerous weapon, the victim in that case is Mr. O'Connor.
Okay, and that's the burglar?
Yes.
Okay. Now, your client may not be able to testify against the guy who was robbing him because he'd have to testify against himself.
That's correct. Mr. O'Connor, coincidentally, is scheduled for pretrial conference on the date of David's arraignment this Wednesday in Hingham District Court. I imagine the attorney for Mr. O'Connor is going to send that case to the trial session. That being said, my client would be forced to invoke his Fifth Amendment right, as he would be offering testimony against himself and unable to testify against Mr. O'Connor. As a result of that, Mr. O'Connor is presently at the House of Correction being held on bail, would be released.
So there's a possibility that the owner that was robbed may end up in jail, and the guy who is doing the robbing walks away.
In theory, that's correct. With the lack of, David has no record, so he won't be going to jail on this case. In fact, it's a very triable case. I would have no problem defending him at trial. But in theory, you're correct.
Okay. Michael, thanks a lot. We'll follow the case. Now, coming up.